He claimed to be doing this under the God-given right to preach in public places, on the streets and sidewalks, from door to door, and whether in apartments or whether in the country or whether in the deepest jungles of Africa. He had arranged to hold a public lecture at 8 p.m. on August 20th in Monroe Park, a public park across the street from Monroe Terrace. Between 7 and 8 p.m. on that day, he and 4 other Jehovah's Witnesses entered Monroe Terrace for the purpose of calling upon the tenants in each apartment to deliver religious tracts and to invite the occupants to attend the lecture. Neither the accused nor his associates sought permission to visit the tenants. The accused was assigned to call upon the occupants of the 10th, 11th, and 12th floors and use the elevator for that purpose. After he had completed his door-to-door calls upon these floors, he went outside the building where he was informed by a Mr. Cahoon, one of his associates, that the work had not been completed. He and Mr. Cahoon re-entered the building and went to the desk, and according to the testimony of the accused, Mr. Cahoon told them, "We were engaged in missionary work and were putting on a lecture in the park." The lady said to give her the handbills, and she would see they were put out. About that time, it was past 7 and the lecture was to be at 8, and Mr. Cahoon explained the obligation was upon our shoulders, and besides, it would be the same as some Western Union boy delivering the handbills. That the obligation rests upon us, and we explained this obligation was on us, and that it was important for us to call upon the people. She said she could not give permission. He said, "I am not asking for permission, and if you will not let the elevator girls take us up, we will have to walk." Such was the account of the court in the case of Dan Leroy Hall v. Commonwealth of Virginia, decided in 1948 by the Supreme Court of Appeals in the city of Richmond, a case involving the first challenge to the criminalization of the former tort of trespass, a measure that had become a criminal offense around the time of the rise of Jim Crow laws, lynchings, and an inchoate civil rights struggle. Describing the issue, the court wrote a common sense test as to whether the court has struck a proper balance of these rights is to ask what the effect would be if the right given to these witnesses should be exercised by all sects and denominations. If each competing sect in the United States went after the householder by the same methods, why, I should think it intolerable. If a minority can put on this kind of drive in the community, what can a majority resorting to the same tactics do to the individuals and minorities? Can we give to one sect a privilege that we could not give to all, merely in the hope that most of them will not resort to it? Religious freedom in the long run does not come from this kind of license to each sect to fix its own limits, but comes of hard-headed fixing of those limits by neutral authority, with an eye to the widest freedom to proselyte compatible with the freedom of those subjects to proselyting pressures. Reviewing the record, the court concluded the inner hallways of apartment houses are not to be regarded in the same light as public roads, streets, or highways, even when the naked fee of the latter is privately owned. As was said in Hague v. Committee for Industrial Organization, wherever the title to streets and parks may rest, they have immemorially been held in trust for the use of the public, and time out of mind have been used for purposes of assembly, communicating thoughts between citizens, and discussing public questions. Such use of the streets and public places has from ancient times been a part of the privileges, immunities, rights, and liberties of citizens. Does the foregoing mean that the inner hallways of apartment houses, merely because they must be traversed from the street in order to reach the actual apartments wherein the tenant reside, likewise are burdened with the rights which public has in streets? Do such inner hallways constitute places of public assembly, or for communicating thoughts one to another, or for the discussion of public questions. In the opinion of this court, the answer to those questions is clearly no. Those familiar with the practice of discrimination law are certainly familiar with the concept that is often described as mere pretext, or an articulated rationale that conceals a discriminatory motive, or as the U.S. Supreme Court described in its 1981 decision in Texas Department of Community Affairs v. Burdine as a proffered explanation that is unworthy of credence, which, in the facts of the whole case, the apartment concierge had attempted to employ against the Jehovah's Witnesses, on the assumption that they were wholly ignorant and would simply take her at her word, since they were not only religious fanatics, but also apparently black and uneducated, when she had asked them to provide her with the religious tracts so that she could distribute them on their behalf to the apartment residents. But the criminal defendants were determined to be non-compliant and informed her that they were not seeking her permission and were like the Blues Brothers on a mission from God. And for those who might describe themselves as possessing a passion for politics and a reason-based policy, the case of Hall v. Commonwealth, brought on appeal to the State Supreme Court of Appeals from a charge of criminal trespass, provides some illustrative details as to the reasons why the legislature had chosen just 15 years before to convert what had been a tort matter to be decided in criminal courts, finding on Jehovah's Witnesses as criminals in those courts, opposed to civil courts, and brought on appeal at the same time that in the case of Carter v. School Board of Arlington County, that arrived on appeal at the Fourth Circuit in 1950, when the county of Arlington had been challenged for refusing to finance the public education of Negro students, for whom an inadequate number of segregated schools had been provided. An interesting achievement gap, and who were therefore required to seek acceptance in the public schools in the nation's capital across the Potomac. A trip for which they would not pay, an education for which they would not pay. And here the court goes to great lengths to describe the wave of religious zeal among Jehovah's Witnesses that had disrupted the privacy of persons around the nation, with which most in the community could agree, but is very reticent on any particular reference to the race of the criminal defendants, who could only have been blacks who were trespassing in an apartment for whites only. A pretext. But most intriguing about this case involving religious devotional practices that had been presented to a court of appeals was that the accused who continued to fight the case in the courts were Jehovah's Witnesses, which only to one familiar with this religious denomination would present an anomalous pattern, because that religious denomination refrains from all politics and does not generally engage with what they describe as the earthly kingdom and authorities, raising the question as to why one might find Jehovah's Witnesses engaged essentially in political activism in the courts, which is a pattern that continued to occur, particularly around the time after 1943, when the United States Supreme Court decided the case of West Virginia State Board of Education v. Barnett, the case with which one may be familiar during the recent Take a Knee protest at sporting events involving African Americans, for it was the case in which the High Court had ruled that no one can be forced to participate in patriotic rituals such as the Pledge of Allegiance and the National Anthem, seeming to suggest that perhaps someone was bamboozled again. And within the context of judicial activism, a concept with which I possess an intimate relation, having served as a childhood protege of one of its legends, a criminal defense and civil rights attorney. These choices of religious persons present a pattern that arises by something more than mere serendipity and more indicative of directed choices in a larger, subtle strategy of a wolf donning sheep's clothing to be revealed at a later time, under the pretext of education, perhaps, like those hospital workers in the Conway Regional Health System in Arkansas who discovered, waking up surprised, that suddenly a Cavalier gentleman, Mephistopheles, had provided evidence that they had already signed a contract and provided them reasonable notice in their at-will employment that unless they agreed to the terms only new to them, that that relationship had been terminated for irreconcilable differences. As Paul writes in his epistle to the early church at Ephesus, "For we wrestle not against flesh and blood, but against principalities, against powers, against the rulers of the darkness of this world, against spiritual wickedness in high places. To those in faith, behold, for you are sent forth as sheep in the midst of wolves. Be ye therefore wise as serpents, and harmless as doves, that ye not wake up surprised. And I charge thee, therefore, in season and out of season, reprove, rebuke, exhort with all long-suffering and doctrine. For a time has come, when they will not endure sound doctrine, but after their own lusts, they heap to themselves teachers, having itching ears. And they turn away their ears from the truth, and shall be turned unto fables. But watch thou in all things, endure affliction, do the work of an evangelist, make full proof of thy ministry. Live long and prosperous, God. This briefing is unclassified, as you were. My name is Major Mike Webb, and by God, I am running for Arlington Public School Board. Let's keep Mike Webb away from our school. Carry on. This advertisement was authorized by Mike Webb.
I used to be a Power Ranger in a former life.
Thunk, I could have had a vaccine.